How are you doing, Professor Rajkumar?
Very good, ma'am. So good to see you, and everything is well. We have been very actively.
We are live, sir.
Okay, great. We'll catch up. Yeah.
Good morning, everyone, and welcome to this launch webinar for the LLM programs in IP and technology law and in dispute resolution in the blended learning mode. This will be followed by a panel discussion on the future of legal practice in intellectual property and dispute resolution. My name is Pratik Bhattacharya. I'm an associate professor at the Global Law School. Let me briefly introduce to you all the panelists for today's webinar. We have Professor Dr. C. Rajkumar, who is the founding Vice Chancellor of Jindal Global University, as well as the Dean of the Jindal Law School. We have the Honorable Mr. Justice A.K. Sikri, who is an eminent jurist and former judge of the Supreme Court of India, who was sworn in on the 12th of April 2013 and served until 6th of March 2019, when he retired as the senior most puisne judge of the Supreme Court of India. Justice Sikri has been in the legal profession and a jurist for almost 20 years, and he has penned historical judgments granting legal recognition to gender identity in the Nalsa case, upholding the rights of disabled in Jija Ghosh versus Union of India, and on issues of arbitrability regarding allegations of fraud in Ayasami versus Parasivam. He is presently an international judge at the Singapore International Commercial Court. I thank Justice Sikri for attending the webinar. We have thereafter Justice Ms. Pratibha Singh. Justice Pratibha Singh completed her 5-year law course from University Law College of Bangalore and graduated as the first rank holder from Bangalore University. She was thereafter offered the Odas Scholarship by the Commonwealth Trust to pursue her LLM at the University of Cambridge. Before being elevated to the bench, Justice Pratibha Singh was a leading intellectual property lawyer in India and was designated as a senior advocate by the Court in December 2013. In May of 2017, she was elevated as a permanent judge of the High Court of Delhi. While she was in private practice, she had the distinction of handling landmark matters in all areas of IPR laws, including patents, trademarks, designs, copyrights, plant varieties, internet laws, etc., and so on and so forth. She has regularly appeared before the Honorable Supreme Court of India, the Honorable High Court of Delhi, the TD site, IPAB, trademark, and patent offices during private practice. She was also a member of the IPR think tank, which was entrusted with the momentous task of drafting India's first national IPR policy, which was released in May 2015. Justice Pratibha has also been awarded as the 13 Most Powerful Businesswomen in India award by the Business Play Group in September 2018. Our next distinguished panelist,
Good morning.
Praveen Anand, who is an intellectual property lawyer for 42 years with extensive litigation experience in patents and trademarks. He has served as president of several and international associations of intellectual property attorneys, such as the AIPPI Indian Group, the APA Indian Group, FICPI Indian Group, as well as a board member of the INTA. He has been on the editorial board of a number of publications, including Computer and Telecommunications Law Review, the Patent Lawyer, the Australian Journal of Competition and Consumer Law, and the author of Hargreaves Laws of India on intellectual property. He has created various games and published books related to IP for spreading the message of intellectual property. He is a science graduate from Delhi University and holds a law from Delhi University as well. Thank you for joining us today. Our next distinguished panelist is Mr. Ronnie Screwvala, who is a first-generation entrepreneur who pioneered cable TV in India and went on to create a media and entertainment conglomerate, UTV. He co-founded Upgrad in 2015. Mr. Mayank Kumar and Mr. Farooq Gombali. He has authored a book on entrepreneurship titled Team with Your Eyes Open, and another recent one titled Skill It, Kill It. Newsweek has termed him as the Jack Warner of India. Esquire rated him as one of the 75 most influential people of the 21st century, and Fortune recognized him as Asia's 20 most powerful people. Ronnie is also passionate about social welfare and is active with his wife as founder trustees of the Swadesh Foundation. I'd like to thank all of our panelists today for joining this morning. First and foremost, I'd just like to discuss what the blended LLM program is before I hand it over to my Vice Chancellor, Professor. Global Law School last year partnered with Upgrad to create this LLM program in a blended learning mode, which is aimed towards legal professionals, with the idea that we provide flexibility towards all of you. So you can complete your LLM degree while not leaving your 9-to-5 jobs. And this particular launch is, of course, we are expanding. We previously had a specialization in corporate and financial law. We now see and foresee a future in intellectual property and dispute resolution, which we believe is the future of the legal profession in India. And that's what we're here to discuss today. I would invite my Vice Chancellor, Professor Dr. C. Rajkumar, to welcome all of you as participants to this webinar.
Thank you very much, Pratik. First of all, I would like to extend my heartiest congratulations to all the students, rather learners, as we call, to this program. It is indeed my proud privilege to welcome all of you who have joined the LLM program in intellectual property and technology law and LLM in dispute resolution. We are, of course, very delighted that this program is being launched today with a very outstanding group of individuals who have represented and have done extraordinarily well in various facets of legal profession. I would like to extend a warm welcome to Honorable Mr. Justice Arjun K. Sikri, former Judge, Supreme Court of India, Honorable Ms. Justice Pratibha M. Singh, Judge of the High Court of Delhi, Mr. Praveen Anand, Managing Partner, Anand & Anand. I also want to extend a warm welcome to our collaborator, partner, and in many ways, somebody who have been from the very beginning joining us in this endeavor, Mr. Ronnie Screwvala, Chairperson of Upgrad. I also want to pay tribute to his colleague who's not with us today, Falgun, from Upgrad, all of whom have contributed to the creation of this program and its evolution. Now, of course, a very important confession to be made in the beginning itself. I am neither an intellectual property rights lawyer, nor I have worked in the field of dispute resolution. But what I thought I will do is to briefly introduce the university and indeed the journey that the university has covered in the last 12 years, and to welcome all of you as learners to OP Jindal Global University and Jindal Global Law School. What began as a very powerful idea in the year 2009 with a single school, the Jindal Global Law School, and with only 100 students and nearly 10 faculty members, has today grown into a multi-school university with 12 different schools in law, business, international affairs, public policy, liberal arts, journalism, communication, architecture, banking and finance, environment and sustainability, psychology and counseling, languages and literature, and the most recent one, the Jindal School of Public Health and Human Development. We began a little over a decade with a vision to provide world-class education. And today I'm delighted to share with you that JGU has grown into an institution that brings faculty members from 41 countries in the world, students from 20 countries, and have collaborated with over 300 leading institutions from 65 countries to bring international experiences to the Indian higher education system. As we have grown stronger with nearly 8,000 students, we've also ensured a consistent expansion of our academic community to bring quality education. The university has recruited this year over 100 new faculty members, and we now stand strong with over 900 full-time faculty members. The law school alone has nearly 500 full-time faculty members, becoming one of the largest law schools, law faculty in the whole of Asia. With great humility, I would like to share with you that with all our collective efforts, this has culminated in OP Jindal Global University being recognized as India's #1 private university by the prestigious QS World University Rankings 2022. JGU has also been ranked as among the top 150 universities globally under the age of 50 years by the QS Young University Rankings. We've also made significant progress in school level rankings, and I'm happy to report to you that the Jindal Global Law School has been ranked as India's #1 law school and been ranked as world's 76th law school by the QS World University Rankings by subject. I also want to mention that last year, the Jindal Global University has been recognized as an institution of eminence by the Ministry of Education, Government of India, an honor and a distinction given only to 10 public universities and 10 private universities as a part of the vision of our Honorable Prime Minister to develop world-class universities in India. Of course, at this moment, it's important to recognize that last year we were faced with one of the most unfortunate and unprecedented crises of our time. The COVID-19 pandemic has been a humanitarian tragedy worldwide. And I would like to take a moment to express my heartfelt condolences to everyone who have lost their near and dear ones. All of us have come together to overcome these trials and tribulations. And I can only hope that the learning project that we have all initiated is not interrupted even during these difficult times. And that's where the visionary leadership of people like Ronnie Screwvala and Falgun and Upgrad as an organization has reimagined the future of Indian education. On this joyous occasion, the most significant outcome of our efforts is the idea of launching innovative programs that will resonate with professionals for advancing their vision and aspirations and goals professionally. The achievements across this year particularly outlines the adaptability and extraordinary ability of our students and faculty to overcome these trials and tribulations, and it underscores the strength of their character and the courage of conviction. A very special thank you to all the faculty members who have mentored and guided our students and have also involved in launching of these programs, starting with the Executive Dean of Jindal Global Law School, Professor Srijit, the Director of the Center for Postgraduate Legal Studies, Professor Vishwas Devaya, and of course, the head of these programs, Professor Pratik Bhattacharya. I am deeply grateful to them for their passion, commitment, and dedication. I also want to recognize for all those learners who are part of this program, let me tell you that next year, you will become alumni of OP Jindal Global University. And some people may ask you, where is it located? Because for all you know, you may or may not be able to visit the campus during this time. Of course, after the Tokyo Olympics, you could say that it is the Olympic capital of India. 1/4 of the Indian contingent, the highest, went from Haryana, winning 4 of the 17 medals. At least 6 members of that contingent are from Sonipat, the district with the highest number of Olympians this year, and a sporting record that should make you proud. Haryana's own contribution is stellar, with 31 athletes of the Olympic contingent from one small state of India. Not just modern sporting legacy, but Haryana and Sonipat have an enigmatic history dating back to more than 4,000 years ago, when one of the most advanced civilizations known to humankind, Indus Valley civilization or the Harappan civilization, flourished right here. It is now regarded as the beginning of Indian civilization. Until 2014, archaeologists argued that Mohenjo-daro in Pakistan was the largest among the 2,000 Harappan sites known to exist. But recent discoveries at Rakigari in Haryana's Hisar district make it the largest Harappan excavation. Not just history, but the location of our university, Sonipat, is found in the epics, replete with myths and legends and Vedic references. It is believed that this region provided the backdrop to the epic of Mahabharata. Names of modern cities still carry references like Kurukshetra from the great battle of Mahabharata. Through oral history, Sonprashta or Sonipat traces its lineage to the epic. But the most intriguing historical fact is about where we are physically located. That is in the middle of Jagdishpur village, the original Grand Trunk Road on the Uttar Path, one of the world's oldest roads connecting major countries of the Indian subcontinent, passed right through what is now the campus of OP Jindal Global University. A course minar or milestone on the GT road, built during the time of Jahangir and Sher Shah Suri, stands near one of our campus adjacent gates to the student housing block. This is where global trade may have started, connecting people from unknown lands. So you belong to a region that has been a crucible of our great Eastern civilization, witnessing the rise and fall of empires. Always remember this and feel a sense of pride in where you have come from, and that is the university you have enrolled today. With those words, I would like to once again extend a warm welcome to our distinguished guests. Each one of them have inspired us quite remarkably from the early days of our founding in the year 2009 and to this day when we are growing in leaps and bounds. I'm grateful to them for their faith and trust and belief in our vision of building a world-class university. I would like to end by sharing a remarkably inspiring words by none other than the father of our nation, Mahatma Gandhi. And he said, and I quote, "A small body of determined spirits fired by an unquenchable faith in their mission can alter the course of history, unquote. I sincerely hope each one of you are those determined spirits fired by an unquenchable faith in your own mission, and indeed you can alter the course of history. Thank you very much.
Thank you, Professor Raj. Thank you for those very memorable words. I'm just going to take a cue from the Grand Trunk Road and how it was a connecting point for various civilizations. And as we are heading towards a more globalized world, I'd request Honorable Justice A.K. Sikri to give us a few words, a few thoughts on where globalization is leading the legal profession, particularly in terms of global intellectual property and dispute resolution, in terms of arbitration, mediation, which is now becoming the byword of dispute resolution in today's day and age. Justice Sikri, you're on mute.
Thank you, Prateek, and good afternoon to all of you, including my, I can say, colleague. I don't know, I should say colleague or ex-colleague, because I'm not a part of the judicial system any longer. Justice Pratibha Singh and Praveen Anand, a very dear to me in so many ways. We have rubbed shoulders as advocates, and then he appeared before me when I was judge. And even now in other form, the association continues. Mr. Roni Skriwala, Professor Rajkumar, and good afternoon to all dear students who have joined today. And I think that, let me start with two comments. Number one, to the students, that it is really a proud moment for all of you. And I think you have taken a very, very wise and significant step by joining these courses, whether it is in intellectual property and technology law or in dispute resolution. And in this process, I would also say that this is a visionary step which is taken by OP Jindal Law School for so many reasons, which I'll come to and address in the next few minutes. What I want to say here is that, look, ever since India ushered into the era of globalization and became a part of this liberalization and globalization, which we say in 1991 and onward, we have not looked back. We know the kind of progress, economic and other progress, which we have made in last 30 years. And our growth of our GDP had been one of the highest. And most of the time, sometime in some years, number one, but most of the time, number two also after China in many years. So that is also all a part of history. But what I'm trying to say is here, we are not discussing about the Indian economy, but the impact of this globalization or liberalization insofar as legal landscape is concerned. And that becomes a very, very important thing. The laws, particularly, I mean, all kinds of laws of practice. I remember when I joined profession in 1977, and from there, when we came to 1991, and before I became judge in 1999, the kinds of issues in the same, subject matters which we were grappling with in the beginning, and how the total, there was change in the context of those cases and the ramification of those cases. I give you the example of, say, arbitration law. We know in our law, we had studied simply Indian Arbitration Act, archaic law of 1940 at that time. And we were, although New York Convention was there, then we had some international arbitration matters, and under New York Convention, how the international arbitration awards are to be enforced in India was still there, because this convention was signed in 1958. But there were hardly any cases insofar as India is concerned, very, very few cases. And I have seen in last, in my practice, we were dealing with only those kinds of local cases. And this position, of course, as I said, in 1991, we became part of this globalization, but it took some years to take effect. And it is only when I became judge and I saw many international arbitration cases started coming up, and at various level and various. And today, as a after my retirement as an arbitrator, when I see the arbitration word, it is there are not only at international level, but many complex issues which arise. Same thing is in respect of intellectual property matters, which of course both Justice Pratibha Singh and Mr. Praveen Anand will throw more light on that, and insofar as this particular subject is concerned. But the fact remains, and because of this, when there are international ramifications, cross-border ramifications of various laws, and the laws also need uniformity. And it was for this reason, we call it in legal language convergence of these laws. And it is for this reason UNCITRAL came out with the model arbitration law, on the basis of which in 1996, Indian Arbitration and Conciliation Act was enacted, which is in tune with this model international modern arbitration law, as shown to us or given to us by UNCITRAL. And almost, I think maybe more than 150 countries now have the law on that basis. So therefore, it is to bring uniformity when the issues of the conflict in private. Many of you may have read in your law course private international law or conflict of laws as a subject. But then this is to take care of certain kinds of issues. And when it comes to intellectual property, you may have seen, those who have already done, because you are doing LLM course. So if you have studied the intellectual property laws in your LLB, must have seen that, look, we came out with a totally new trademark law. There were sweeping amendments in the Copyright Act. There was sweeping amendment in the patent law. This was to conform to the standards of WTO or WIPO, which they wanted us to have that, so that there is again convergence of law, which is. So today, our statutory regime, insofar as intellectual law is concerned, it's international compliant. But why it is all necessary? Now, in this whole process, what I wanted to say, and this convergence of laws, etc., that today, when the students are to study these laws, then it becomes important and it becomes necessary that they know what is happening at international level. And in that context, I would say that you, as I said earlier, many of you may have studied this intellectual properties laws in your LLB, but then LLM course with technology is blended with intellectual property, which becomes very important insofar as patent issues are concerned, and many times even these trademark issues, etc., are concerned. That is one aspect. And more than that, this international perspective of these laws that might not have been your course contents when you had studied it in LLB. So therefore, I may say that to train all of you, and that is why I said it's a very important step which you have taken to shape your career on the one hand, and that is why I said that it is a visionary step which is taken by O.P. Jindal Law School in introducing this subject, because it becomes, it will bring our students who are trained in such laws to make them international lawyers insofar as this field is concerned. And coming to this dispute resolution, this I would say is very, it's a need of the hour. I may say so for various reasons. First reason, COVID. If you know, till 1.5 years ago, the arrears as far as Indian courts are concerned, 30 million cases in the district courts, about 3 million or 3.5 million cases in the high courts and about 55,000 cases in the Supreme Court. In 1.5 years, this figure has gone up. From 30 millions, it has gone to almost 40 millions as far as district courts are concerned. High courts from 3.5, it has gone to 4.5 million. And Supreme Court also, it must have, I don't have the figures, but may have crossed 60,000 cases. But in this scenario, the question of alternate dispute mechanism assumes much more important. And COVID has taught us another thing, which of course is now the topic, or rather the forte of Mr. Roni Skriwala, that is Upgrad, that online education. It is, I tell you, COVID has taught us that our even legal system or judicial system in future is going to be a totally different. It may not, that the new normal is there. We may return to normalcy. There would be physical hearings in the court, but it is possible that it would be a blended or a hybrid system where online dispute resolution, or what we call ODR, is going to play a very important role. So therefore, this online ODR, when it is important for the judicial system, it is important for education system also. But in the whole process, what I was trying to say is that ADR comes into picture with significant proportions, and in the whole in this context, the mediation takes central stage. That is my conviction. And of course, in 2002, with the amendment in CPC, introduction of Section 89 CPC, where mediation as one of the forms of resolution of disputes was introduced, and in 16 years we have made strides, no doubt about it. Yeah, and in the process, it is also that in order to encourage mediation, it has become a course of studies in various law schools also. But up to now, it had been only like a diploma course, 20 hours or 40 hours training for a person to become mediator. But what is more important is that we have to, in 16 years, the strides which mediation has made, coupled with COVID, coupled with online, and more importantly, last year, and it was, today is 11th September, 12th September, exactly 1 year ago, when Singapore Convention on Mediation was signed. Now, that has changed the total, it has given a paradigm shift insofar as mediation is concerned. As I told you about the New York Convention, now New York Convention, where the arbitration awards are passed, how they are to be enforced when it is passed in one country, but how it can be enforced in other country as well, is the mechanism provided there. But now UNCITRAL here also came out with the model, this law on this convention, insofar as mediation is concerned. If mediation is decided, a settlement takes place between the two parties who may belong to two different countries, and how it can be enforced, it's merely a settlement. How it can be enforced, Singapore Convention takes care of that. Of course, it is UNCITRAL convention, as I said, but since it was signed on this sometime in December 2019 and came into effect from 12th September 2021 in Singapore, therefore it is called a Singapore Convention. But then, let me here tell you one or two things insofar as dispute resolution today, why it is important. Number one, and I am of the firm belief, in many situations and many circumstances, and in many contingencies which are faced with in a litigation, the mediation may be the better form of access to justice than arbitration or the legal system. I have written a detailed article. I've written almost more than maybe 10 articles on mediation, and I can share with you, Prateek, since you are going to have this LLM course now with them. But One is about the jurisprudence of mediation and why it is necessary. And therefore, going by that, I feel that at times it becomes a better system or a better methodology of access to justice, because the kind of justice is provides in the form of resolution of this dispute, which results in win-win situation, there can't be any parallel to that. And another thing which I want to say, I had touched upon this aspect that, look, it is very important not to lessen the burden of the courts. And here I have said that it is even a better form of access to justice. It is helping judicial system today by lessening the burden. It is helping arbitration system, because most of the arbitral institutions in the world, they now say that before even going to arbitration, you should explore the possibility of mediation first. And we have the systems like MEDARB, MED, or ARB, MED, all these combinations, etc., which you will be able to learn only in LLM course, which are today become the necessity. And such techniques are to be learned and are to be understood by all of us. And so therefore, mediation is the savior of arbitration. Mediation is the savior of judicial system to some extent. So therefore, the importance of this mediation and how there has to be a higher course in mediation, and how, and it is going to become, and it has become in Western world, a full-fledged profession, and it should be here as well. And for that reason, mediation as an LLM course is really a remarkable step. And that is why I started with this, that it is a visionary step which is taken by OP Jindal Law School. And I congratulate Professor Rajkumar, you as well as Prateek, for this venture. Those would be my introductory remarks. Thank you.
Thank you, Justice Sikri, for those very kind words and that crystal ball gazing regarding the legal profession. I now hand it over to Justice Pratibha in connection with what Justice Sikri discussed about enforceability. As the world becomes more global and as we have multinational companies, digital economy and digital platforms, do you see a difficulty in enforcement of intellectual properties or in any kind of clauses, arbitrary clauses, which might be there in any kind of agreements in multinationals?
A very good afternoon. Thank you for the question, Prateek. Justice Sikri, our mentor, always, Mr. Praveen Anand, Professor Rajkumar, and Mr. Skrugala. It's a pleasure to join you all. I do see that, as we go forward in this particular ecosystem currently, intellectual property enforcement is becoming much stronger, but with greater challenges. And why do I say that there are greater challenges for IP enforcement and IT enforcement? I do think that in India, a law school like Jindal has a very big role to play in the sense of creating the knowledge base and the human resource to handle challenges which are going to be coming in the future. And let me give you a very small example about how the law profession itself in India is evolving, which will actually make us all sit back and think as to how we need to recalibrate the profession and the education being given in law. If you see that there are about 4 lakh students who enroll into law every year in India, but less than 1 lakh graduate out of law school. So it's less than 1/4. In the postgraduates, it's about 1/3 of the people who enter. A large number of the postgraduates are even women. But what is it that we want in the legal ecosystem in the future, which is where this course provides a very big message to the community? We require experts who are good at physics, chemistry, microbiology, biochemistry, data analysis, artificial intelligence, engineers who can do construction arbitrations, economics, analysis of economists who can give evidence in court. For example, in standard essential patent cases, we've had economists who come in and depose in court. We have had accountants who come in, tax experts, chartered accountants, cost and work accountants, All of these people are already being used in IP and technology cases to come and give evidence in cases. And if you look around as a judge, I'm sure Justice Sikri has faced this difficulty, and today we face it much more in the Delhi High Court. In a patent matter or in a technology related matter, if I look around, if I need an independent expert to just purely, brief the court, assist the court, I don't have anyone. So we need to create a huge amount of human resource in our country who can help the courts and the litigation system to, to flourish and to do much more and to be more efficient. Let us look at the opportunities which lawyers have as, for example, career. The traditional ones are all corporate lawyers, litigation lawyers, in-house lawyers, like, they work in companies. Now we have the new kind of legal opportunities, like in policy bodies, legislative bodies, legal journalism, academics like in Jindal, judicial services, law researchers. I can't, emphasize how important law researchers have become for judges to function. Today, I can't imagine functioning as a judge without 5 or 6 law researchers. They form an important element of our judicial dispensation. Now, what do we need as we go forward? We need managers for the judiciary who know the law and who are also MBA holders. Where are those courses which provide management plus law? We need software programmers who can sit down and make, analysis of legal, judicial disposal data, the kind of cases which are coming in, data analysis, artificial intelligence across the world, at least in the US and in some other jurisdictions. Bail orders can be created through artificial intelligence. Data analytics can be done through artificial intelligence. Negotiable Instruments Act cases can be disposed through artificial intelligence. Extensions and smaller formal applications under the Arbitration Act, we can use AI for that. We can have standard orders which are generated, which can be just modified by the judge depending on the facts of each case. So we do not have the human resource trained in law plus allied fields. So whether it's sciences, whether it's engineering, whether it is economics, accountants, software programmers, managers, we do not have enough human resource as of today. And I think the course that you're starting today on IP and IT is going to be so important for such an audience because, for example, the only 1 or 2 courses which come to my mind, which are already there and which are a huge success. There's one by the Department of Science and Technology for women who are housewives, who are science graduates. So they train them, about 100 women who are selected every year. They train them as patent agents every year. And each of those women, it's almost like a 90% recruitment which takes place every year. So we have a very huge volume of untapped potential of people who are doing jobs, but they want to, skill themselves or upskill themselves, if I may say, like with upgrade kind of platforms. And I do think that we need to provide these platforms. And unless and until we provide these platforms, we won't be able to create the human resource that we need for the next 20 years in our country. Because if we don't create the human resource, the litigation won't happen, the efficiency in litigation will reduce. And therefore, I do think the time has come for, law to be introduced into various other colleges or in collaboration in some way, whether with the IITs and the IIMs and even with the normal universities, which we see. I think we need to have blended programs with law and other technologies. Now, lastly, I can only say one thing, that I think that Jindal Global is doing as a law school. I think I have a little bit of a bias towards you people because a number of my law researchers come from Jindal, and I must say that the Jericho, the division that you've created, it's doing some excellent work, and I've seen some very good publications of Jericho. And in the field of IP and IT, the most important thing I would like to highlight about Jindal as a law school is the amazing faculty that you have. You actually recruit the globally best faculty, and that makes all the difference. That gives you the brings you to stand apart compared to most other law schools in the country. And I'm sure Justice Sikri is aware, and I don't know why they've shut it down. A large number of people have told me that the Delhi University Evening College course, which was there with bureaucrats and academicians and others, used to pursue. I thought it did a great service to the profession. I think that should be started again. Until we can do those physical courses, I really think that the online platform is the platform going forward. So if you can have, not just IP and IT, but, economics related courses, tax related courses, IT related courses, data analytics, and I see the AI part of course curriculum that you've already got. I think it's brilliant. We need these lawyers who are trained in these fields. I think the judiciary needs to use them. The society needs to use them. I just feel when I was thinking about it, I feel law is like the salt for society and the economy. Without salt, there can be no food. In the same way, every facet of society and economy today needs law, whether it's administration, whether it is industry, whether it is management, whether it's studies, whether it's education. I can't think of a specific field where law you can do without law. And therefore, I think law needs to be integrated into various courses, and we should be producing people who could do dance plus law or music plus law. I mean, look at the copyright industry. Someone who doesn't understand music can't deal with copyright. Someone who doesn't understand technology and IP and creativity can't deal with online infringements. It's not possible, because unless and until you have the basic knowledge of that field, it is not possible to deal with those disputes. So I think that your dispute resolution course and the LLM course, I would think that this is just the beginning, Professor Rajkumar. You should be offering maybe 100 courses like this as you go forward. And I really wish you all the very best. And whatever all of us as, in the domain expertise, which all of us have, whether it's Justice Sikri or Mr. Anand or any of us, we would be willing to happily contribute to this. And it's a great venture. And I wish you all the very best. All the students, this is the right decision you've taken. It's going to open up your career opportunities in a very big way. And wishing you all the best and success in the courses which you're going to have.
Thank you very much, ma'am. Well, you have been an early supporter, like Justice Arjun Sikri, who been a big champion of us even before. But I want to share something that you said. One of the major challenges of Indian legal education is the fact that we ended up creating these stand-alone law universities, which has unfortunately to a large extent impacted adversely the possibility for promoting interdisciplinarity. We are very fortunate that we are not a standalone law university. We are a comprehensive university with 12 schools. Each of those students are engaging with the other. Each of those faculty members are engaging with the other. And so all you said, music and theater and drama and all of that is happening along with law and business and policy. Believe it or not, every year, every day, from morning 9 to evening 4, we have the core and elective courses a student takes in a particular school. But from 4 p.m. to 10 p.m., we offer 500 plus cross-listed electives every day for students of all schools of JGU to be able to take in the other school. So law students end up taking courses in the liberal arts school, and liberal arts students end up taking courses in the architecture and banking and all of that. The classic liberal arts tradition, which has been promoted in some of the leading institutions in the US. So I take your point. Many more are coming, including data analytics and artificial intelligence and robotics and machine learning and its connections with law. Thank you.
Thank you.
Let me have my pleasure to invite Mr. Praveen Anand. He of course, doesn't need any introduction to this field, but I want to thank him for his commitment towards the legal profession, but also academia. Whenever we have had the opportunity to invite him to engage with our students and also academic institutions, he has never hesitated. I only wish there are more lawyers like Mr. Praveen Anand, whose focus is not just the billable hours, but to build capacity and inspire young people. Thank you very much.
Thank you very much, Professor.
And over to you.
Thank you, Professor Rajkumar, Justice Sikri, Justice Pratibha Singh, Mr. Ronnie Screwvala, Pratik, dear students or learners, as Professor Rajkumar called them, and of course that expression includes me. I'm delighted to be here today on the launch of this LLM program in IP, technology law, and dispute resolution. And it is my belief that Indian IP law has come a very long way. So naturally, I would look at three quick aspects given the shortage of time. One, what have we achieved? Two, what are the flaws which are immediately apparent in the system? What is our future? So let me start by just recounting what I believe we've achieved. And it's a long story. To compress it in 1 minute is difficult. But I would say broadly, we've achieved a time revolution. We've squeezed the lifespan of litigation from about 5 to 10 years to about 1 to 2 years. And that's a major, major achievement. We've achieved that through changes in the Code of Civil Procedure, through the 2016 Commercial Courts Act, through various rules at high court levels, such as the 2018 Delhi High Court original side rules, where you could serve a party by email. Of course, you could earlier by email, but by SMS, by WhatsApp, you could record evidence outside the court premises over a weekend, and all sorts of other changes which make recordal of evidence and trials really, really quick. So process changes, law changes have helped this time revolution. Second change, remedies. Remedies, we've really revolutionized them. When countries were not granting Anton Pillar orders, we granted Anton Pillar orders, John Doe orders, Mariva injunctions, all sorts of remedies. We even had tree planting orders, where a violator of a patent dispute was directed to plant 140,000 trees on the ridge in Delhi to pay back society. And the benefit of that would go to the plaintiff under the corporate social responsibility. So it was a win-win-win. Plaintiff won because of the corporate social responsibility, defendant had to pay, and society gained. There are a whole lot of remedies like that, which are very unique. Justice Sikri's spittoon order, where a Baba Zarda matter, somebody had copied and the person couldn't pay damages. So Justice Sikri passed an order that he would install 300 spittoons in the Osmania hospital in Hyderabad. It was a way to make him pay back where he couldn't afford to pay damages. So there's a remedies revolution and a time revolution. The third area where we've done very well is non-statutory tort development, judge-made law. We had trans-border reputation and trademark cases, which protected well-known trademarks fantastically, comparable to the best in the world. We had hot news doctrines, we had hyperlinking, meta-tagging, framing, phishing, new internet torts, all without a statute. And judges were looking at all over the world, looking at cases, adopting their principles, taking the best and adapting them to Indian law, even without the backing of a statute. Fantastic work. Mediation, as Justice Sikri and Justice Pratibha Singh mentioned, mediation, pre-litigation mediation helped a long way. Earlier, we thought IP cases would never settle, but from trademarks, we went to patent cases, standard essential patent cases, all of them. Nokia had 9 disputes settled in pre-litigation mediation without filing a single case, 9 major disputes with Indian companies, Chinese companies, all settled in pre-litigation mediation. This is the great, great, great achievement. Flaws. Flaws, final arguments, the entire process, we've addressed service, we've addressed evidence recordal, we've addressed various parts of the process. When it comes to final arguments, we get stuck. We get stuck because although the IPAB was abolished and an IP division created in the High Court, but the judges sitting in the IP division, they hear arbitration and a host of other cases, family disputes, land disputes, etc., and property disputes in families, etc., but not just intellectual property. The result, because there's no dedicated judge listening to intellectual property, the intellectual property case, a trademark case may be easier for a judge to listen to, a patent case gets into the back burner. It takes time, it's complicated, it gets into the back burner. So there's a little bit of a queue up there. So final arguments, that's a flaw. Second, damages have been granted by the Indian courts. Yes, almost between from 2005 to 2021, about 400 cases of damages have been granted, but only 30% have been recovered. So there's no real deterrence. And that is something where we still see as a flaw, that there's no real deterrence, or you could take the other side of the coin, there's no real respect for intellectual property, or at a more granular level, there's no real love and respect for creativity as yet. That's important. Now, future, 4 or 5 quick things in one minute. Discovery, very important to develop the discovery laws of the country so that you can gain what is the sales of an opponent, what are his assets, and that's 1. 2, security laws, so that you can secure the plaintiff while the trial is pending. The defendant should not be able to divert all his assets to other companies, so that at the end of the trial, the plaintiff is successful with a big award in his favor, but he gets nothing because the person has no money. And so the laws to have either pro tem orders or other security orders to secure the plaintiff, those need to be further developed. They are developed, there are some good decisions, but that needs to be concentrated on. So there's money there at the end of the tunnel. Third, time slots. Now, Chapter 18, Rule 4 of the 2018 Delhi High Court Original Side Rules have been amended. Time slots have been introduced, and there are currently 4 cases or 5 cases where judges have said 1 hour plaintiff, 2 hours defendants, 1 hour plaintiff in rejoinder. Time slots have been put in the orders, and it's good that we are getting there. But that needs to be developed so that it cannot possibly be that on a small little point of whether there was service or not service, 45 minutes are wasted of the valuable time of the court is wasted, or 1 hour is wasted. That's time slots, I think, is a very important area where we need to reform our law. Then real damages. Real damages, meaning that damages should not only be granted, but all efforts made to recover them. The heat should be felt by a defendant, which currently is not so, is not the case. Quantitative assessments, evidence-based judgment, which means in order to achieve uniformity, as Justice Pratibha Singh rightly pointed out, use of artificial intelligence, machine learning, statistical models, etc., to come up with more objective analysis of, let's say, likelihood of confusion. Currently, a judge looks at the 2 plaintiff and the defendant things and says, I think it's similar. Another judge says, I think it's dissimilar. There are no objective parameters by which 2 judges can come to the same decision looking at the same facts. And that objectivization is necessary and can be easily achieved, because now we have a mass of case law to feed into a machine learning program, come up with models which can easily predict that this is how it should be. And that prediction report will be like a blood report for a doctor, who then has the decision to decide or diagnose. So a judge could also have, say, according to the past, this case should have been decided in favor of the plaintiff, but I would rather give a little more weightage to factor X, to the dishonesty, than what the model predicts. But that would be an assistance to try and achieve some uniformity in the law. Next, I think it's important for a university to create real love and respect for creativity. I think this can be achieved by making our inventors, our scientists, our creators, heroes of the day. Very important. For my grandson, I wanted to have figurines of Einstein and Newton and Mendeleev and Darwin. I couldn't find them. I could find actors and sports people and all sorts of other celebrities, politicians, but I couldn't find them. So I got them made myself. And I'm very happy that he is now learned about who Darwin is or who Mendeleev is at an age of 2, or what Neil Armstrong is. And I think that's very important. We have to build up that love for intellectual property. We have to love our scientists, our artists, our performers, and make them rich. It's enough that these people, which is a small segment of our society, which gives us our reason to live, apart from, of course, our spiritual leaders, they are the poorest. I mean, it's a deep flaw in the system. Then I would say 2 things we need to learn as skills: precision and relevancy. We think everything is relevant. So McDonald's trademark cannot be protected because their property is in dispute with MCD. So that's relevant. Plaintiff does not disclose that fact, so that's suppression. If it's suppression, he fears, so he discloses everything. When he discloses everything, he makes a pleading of 80 pages and he puts documents of 500 pages. And so it takes a long time for arguments to happen. And so everything is linked up. If judges start to look at relevance as relevance, then plaintiffs will only file that much, deal with that much, and then I think we will get precision, and that will also save time. I would say last point, science and law. In our firm, we call them hybrids, people who have a combination of 2 fields, accounts and law, science and law. As Justice Pratibha Singh gave a beautiful analysis of the kind of various professions which will come up in the future. It's extremely important. When I started to bring engineers into intellectual property, many, many years ago, it started with a lecture at the IIT Delhi. And they said, engineers and law? No way, that can't work. It took 8 years to train the engineers to work with the lawyers. Their cultures were completely different, like oil and water. The engineers would come to the office with T-shirts, with using expletives on the T-shirt, with earrings, with long hair like mine. I mean, whereas the lawyers were always with ties and prim and proper, and they wouldn't use expletives. And it took time for that culture but when that integration took place, believe me, the result was fantastic. Because today we work in our patent teams together, and there's so much of synergy. Because today, at the end of the day, all ideas will never be creative till they link up with other ideas. That connection between idea 1 and idea 2 makes a big idea. Thank you. Thank you very much. Now, let me conclude. Let me conclude by saying, I think I wish all the students a very successful LLM course. Hope you can all assist in researching some of these great areas which trouble us. I may be a little biased, I think. Justice Pratibha Singh said that law is the salt of our society. I may be a little biased in saying that intellectual property is the salt of our society. Thank you.
I think you need to unmute yourself here.
Thank you, Mr. Anand. I'm sorry for that. Thank you so much for your very insightful terms in terms of how the legal profession has changed over time and what the requirements are. And now request Mr. Ronnie Screwvala, chairperson of UPGRAD, to tell us from a business person's perspective, what does the legal profession need, or what do you need from lawyers for tomorrow?
Yeah, thank you, Pradeep. Professor Raj, frankly, you started by saying I'm not a practicing lawyer. I think your oratory skills, your ability to always story tell, you're going back to ancient civilization as to where and how the college has been rooted and what if we were to dig deep down below. Those are actually the charismatic ones. Those are the ones that tell you the most powerful messages. And I think there's a fair amount to learn from there. Justice Sikri and Justice Singh, thank you very much for also joining us and honoring us on this one with your words of wisdom. Praveen, Anand, with your very, very practical knowledge and information. For me, actually, just listening to everyone here was music to my ears. And as the outside person, as the non-legal person here, and to all of you lawyers out there and fellow lifelong learners, everyone is now talking about rounded learning. And I think it's incredible that Justice Singh brought out that, you can't understand intellectual property unless you understand each aspect, because most of intellectual property means you're creating something out of nothing. And then you're arbitrating who actually originated it. And it's a very difficult process. So the whole context that law is a little bit more encompassing. Of course, it needs to be black and white, but then there is the element of interpretation. And I think when you glean through this course, our approach has also been to talk about the theory, but also the practical, because actually the tomorrow is really about how we can put that into practice. Professor Raj talked about the ranking of the university. I don't think any one of you learners and lawyers should take that lightly, because it is extremely prestigious. And I think it adds a lot. It adds in terms of faculty, it adds in terms of gravitas. Thirdly, I'd like to say for everyone here, we've always now got very adaptive to online learning, but I call this present environment as the COVID online learning, which is where everyone actually simply thinks, there's a camera, we're all talking, and everyone must listen. And I need to tell you, especially fellow learners, that the platform and the learning that you will go through is going to be much more intensive, much more deep, and it's not just on listen mode only, because that's not learning. Content consumption is not the same as learning. And I think today we're all looking at it in a temporary patch-up way when we look at implementing what I call the COVID online learning. But the ability for us to actually understand the practicality of it, industry professionals come in and learn, and I think that's something that's very important. As much as things are online, there is an ability today for us to actually have a high touch. Most people think that I need to have been in the physical world, but I think today, online and digital allows us to be high touch. And the career support, and you have counselors that go with that. And I think if I take that, it's like a buddy program that would appear anywhere. And I think I can't think of a better way and a better platform, especially when you're learning something like law, for it to be a group approach. And frankly, that is really where the best of learning takes place. So my deep dark secret is I always wanted to be a lawyer. And I think in the first few years, I would just go across, I remember in the Bombay High Court, and then in Esplanade Court, and then the small courses court, and just sit down and actually observe. And I learned a lot of communication skills. And I also learned a lot of comprehension skills. I was also absolutely fascinated the ability of the power of listening and why that's so important when you're looking at law. Because if you're not listening, you can't argue the next step. There is no scripted message by which you are having any discussion, any judgment, any narrative of any sort. And therefore, I would urge all of your learners to understand how important comprehension, communication, the ability to listen and have an analytical mind is absolutely critical and important, without which we can have all the knowledge in our left brain, but the right brain is not going to be able to create the impact that we need. Lastly, I would just say only one thing. You'll all need to be proud, because I genuinely believe that. And I think Justice Singh also averred to that, law is all pervasive and needs to be in every aspect. And I want to tell each of you, I think you're in one of the most high impact careers of anything else. I mean, on a lighter note, when I tell somebody, I have a very good doctor friend and I have a very good lawyer friend, which means I'm set in life. I don't need a mentor. I don't need this. But I think if you say I have a good lawyer and I have a good doctor friend, you're really set in life, more than even friends. So you are in a very high impact sector, and we hope we can be part of the journey to create that high impact for you. Thanks, everyone.
Thank you, Mr. Skurwala, for those excellent words. And for that is really the future of education as we know it. We're, of course, a little over time, so I'll just take one question from the participants. And one of the participants have asked about what is the, or your thoughts essentially on whether compulsory mediation is an important tool or might be useful for the legal profession to reduce the arrears that courts are facing. So I'd like to request Justice Sikri to perhaps give his thoughts on this question.
Yeah, I think some student has asked this question.
Yes.
So I admire what Roni said that you should be, and he's already there on dot. It's a very, very important question. And this is one of the debates which is going on. If I might say that when Section 89 was inserted, about which I said, and the virus or the constitutional validity of this provision was challenged in the Supreme Court, in that Salem Bar Association case, where the Supreme Court upheld Section 89. And of course, many times I say that I thank Salem Bar Association for approaching the Supreme Court and challenging this, not because they failed in this, but then the Supreme Court took note of such an important provision and thereafter took active steps in promoting mediation. And these are all the efforts of Supreme Court and the judiciary thereafter, that what we have seen mediation about. And that is why I say that I always thank Salem Bar Association. Otherwise, many times our legislation, they remain, only on statute books and a piece of paper only, and not converted into action. But what I'm now coming to that question, in Salem Bar Association, one of the argument was that how you can force a person from arbitrating or from going to mediation, etc. And the Supreme Court said in that case that, look, and particularly though these are the observation, if I remember correctly, are in the context of arbitration, of course, that yes, it is not a process which can be forced upon. It is only when the two parties agree. So if that is the ethos of Section 89, which some may argue may apply to mediation also. And if it applies to mediation, and unless the two parties agree to mediate between themselves, how by either the Act of Parliament or the statutory provision or any other provision, you can force a person to undergo or go through the mediation first before taking up the case in the court of law or for going to arbitration. That is one way of looking at it. The other way of looking at it is that a dispute has arisen, as we said, and we know in this society conflicts do arise, and they are the part of our life, our culture. We can't avoid that. Conflicts would arise, but what is important is for a society to go in a peaceful manner and to maintain law and order, that these disputes should be resolved at the earliest possible. The resolution should come, and mediation is one of the methods for doing that. And so therefore, if dispute resolution is the process for which the courts are established, which is a sovereign function, and that is what is established by the courts, then why not Parliament can also say that, look, before approaching the court, you have to approach through this system. That is how I look at it. And that is what my observations are. And therefore, once it is, even if it is made incumbent, then it is not that it is forced upon, in the sense you are asked to explore that. Nobody is saying that once you are in the mediation process and the mediation is going on, you have to compulsorily settle the dispute also. Mediation may result in no resolution. It is possible mediation may fail. And if it fails as a system, then naturally you go for adjudication either in the form of arbitration or through the process of the court. So therefore, asking, if the legislature wants that the person should be asked to go for this mode of resolution before going there, which we call pre-litigation mediation, even if it is made compulsory, my personal view is that it should be welcomed, more particularly going by the advantages which it has in the system. And that is what the, if you may say that this is not only in India, but it is world over. And Singapore Convention has now proved that mediation, in a way, it's an imprimatur, or it is a seal of approval to the methodology of mediation. It talks of that, yes, now mediation can be a profession. It can be a full-fledged profession. Mediation needs training. Mediation needs education, which you are doing now. That is why I didn't elaborate on that. Yes, as Justice Pratibha Singh said, insofar as mediation course is concerned, whenever you want me, I will be there to give lectures to the students, these LLM students at advanced level, or particularly on the jurisprudential aspects of this and what is needed. And we need a different kind of mediation advocacy. The persons who appear, advocates who appear before the mediator, we need a different approach from the mediator's point of view. There's such a good connect between the mediation and the spirituality. I've written a detailed article on that also. But what I'm trying to say is, going by all these benefits, my answer is, even if it is made compulsory before going, and let me tell you one thing more here. In England, there are, and it is the case law, there are many judgments of the English Supreme Court. Now it is Supreme Court, earlier it used to be House of Lords, which used to do that if you are asked to go for mediation and you refuse that, even in the court case, you win ultimately, you will not get the cost. And the cost in Western countries or in those is not the cost which we give here, symbolic cost of 500 rupees or 5,000 rupees or 10,000. There, as Mr. Anand said, damages in IPR, there the cost is also real-time cost. And if the person had spent, and the litigation cost is it runs sometimes into millions of dollars or pounds. And that cost, if the person, even after success, is deprived of that cost, and that is the ethos, that is the philosophy behind mediation, and that is how the mediation is, encouraged in all jurisdictions, then asking a person to go through mediation in the first instance should be a welcome step.
Thank you, Justice Sikri, for that very comprehensive answer. And we will most certainly take you up on that offer when the course begins. We have, of course, come to a conclusion with regard to this webinar. I'd like to thank all of our panelists. I'd like to thank Justice Sikri for very particularly pointing out on the need for alternate means of conflict resolution, because justice delayed is ultimately justice denied. I'd like to thank Justice Pratibha Singh for particularly focusing on the need for interdisciplinarity, which is something which OP Jindal Global University abides by. I'd like to thank Mr. Praveen Anand for his discussions with regard to the importance of creativity, and Mr. Ronnie Screwvala for the importance on reinventing education as we are entering a new age of education and of learning. I thank you all the participants, and of course like to thank Professor Dr. C. Rajkumar for being the visionary for this university and creating an opportunity for us to have such interdisciplinary thought, discussion, and even students as graduates as alumni of OP Jindal Global University. Thank you, everyone. Thank you all the panelists, and thank you to all the participants who attended today on the Saturday morning.
Thank you. Thank you for having us. Bye.
Thank you.
Pleasure. Lovely. Have a great day, everybody.